Only see the sound, right? All right. So we can only hear the sound. Okay. So, okay, I'm just doing this off the top of my head, right?
Yeah.
So we're going to say to the judge, Iranga Tambariki. Oh, never say that freaking name. Iranga Tamariki removed both of your children and then give the date that they were removed based on two allegations. One, that you abused your children, or what was the allegation that you hit your children?
Oh, I'll have to go back into the file because I don't know whether it was put on file or if it was just false claims made later.
Well, this is we don't want to go into all of that. Just there was an accusation. There was an accusation.
Claims of violence.
An accusation of violence to your children and an accusation that you were a drug addict.
Yep.
Yeah.
And also had an uninhabitable home, which was so far from the
and an accusation.
Yeah.
That your home was uninhabitable.
Yeah.
All right. So you're going to say the removal. You're going to say there was no conviction for any of the three accusations. Have you got that?
Yep.
You're asking the judge for a declaratory order of your right. Now I have to put up the 1688 Bill of Rights so I get the correct thing.
You're right.
Hang on. 1688 Bill of Rights. That your right has been affected.
So I'm asking the judge for a declaratory order that my right has been affected.
Yeah.
Rights have been affected. Yep. You there?
Yeah, I'm just looking, hang on.
Oh, yeah.
Let's see, right has been affected. Let me see, where is it? Okay. That your right has been affected, grants of forfeitures, that all grants and promises of fines and forfeiture of particular persons before conviction are illegal and void. Okay. So what you're saying is you'll have to rewrite this into correct format.
Yeah.
What you're saying is that the Oranga Tamariki granted they granted a forfeiture of your person by removing your children that belong to you before any conviction on the three accusations that they, what's the word here? What am I looking for a word? That they
placed upon my person.
Placed upon my person. Well, they said, but I'm looking for a more legal term. Asserted.
Yeah.
But they asserted. And
asserted. Yeah, and by doing so,
so you're saying that that their grant to remove well we're not, because we're not, we don't need to go into any of the details, because what you're going to do is when you get this declaration, then you're going to take that to the court.
yeah,
And then you're going to say to them that their grant was illegal when you go to the court. So we to the lower court. So we just
okay.
only want the declaration. Now, you're also going to use I don't think you could use excessive bail.
I will use excessive bail because it is relevant,
Right.
especially considering the time frame.
Well, it was,
and that goes into Care Protection Act as well, because it affects the children's sense of time.
so I think that you could put the grants and forfeitures right up there, bang in the at the top of it.
Yeah.
And then down the bottom that you can say that this was also an excessive bail without any conviction.
Yeah.
Or before any conviction was made. So it was an excessive bail, wasn't it? Kind of.
Yeah. Oh, definitely.
So
to uplift without support prior would be considered excessive bail as well, if they weren't willing to offer support if there were ongoing issues.
Then
to just uplift them is considered excessive bail.
Yeah, so this would be an excessive. It would be an excessive bail. An excessive bail without any conviction of my person.
Yeah.
Wouldn't I?
Yeah, it is.
Because somebody just walked on in there and said, hey, she hit her child or something, and they just said, oh, okay, well, we're just going to go and take those children. Here's a grant to go and take those children. But, the truth be known is that if, hitting your children in an excessive way, that is actually a crime in the criminal court. It's a criminal activity to beat your children, right? And then having your children, well, even living, what did they say, living in an uninhabitable
home.
Huh?
They said that the home was uninhabitable, but anybody that you can just look on my Facebook and see that we have a beautiful home.
Well, we're just talking about it. So, and to live in an uninhabitable home, that is actually a health risk, and they're actually supposed to. I mean, it is kind of almost a crime to be living in an uninhabitable home, and that should also have been taken to the court. And beating a child should have been, they have failed because they didn't take you to the court when they knew, apparently, according to them, we're not saying that you did any of these things because there's been no conviction. But if they thought that these activities occurred, these were against the law, and they should have filed a police complaint. And you should have been taken to the court. And during the police complaint, they would have had the right, perhaps, to remove the children for that time. But they did it backwards. They removed the children just because of an accusation, but they didn't follow up the accusation either.
No, this is what they do now. They just uplift them.
Yeah, well, you see,
What they do is they hold an FGC, but they'll look throughout your whole life and see if there's any abusive people in it, and then what they do is they bring those abusive people into this FGC to decide what happens to their children.
What's
Family group conference?
Family group conference.
Yeah. But if you're dealing with a whole room full of people who are either narcissistic or abusive, then how do you, as a parent, actually stand up for your children?
Well, you know, the whole thing is illegal.
Yeah,
the whole thing is unequal and unfair. If you've got a family, if you've been ostracized by your family, or your family has just decided that they don't like you, well, they're going to gang up on you, aren't they? And you know, there are many people. Yeah, and there are many people that leave their families for whatever reason and live very. I've left my family and lived very happy, healthy lives, and there are some vindictive families. But it does say here, according to your rights, that in order for them to give one of these grants, this is any of them, in order for them to give a grant to remove any of your property, whether that be land, houses, children, whatever, they must first get a conviction. So that they get the accusation by your family, or whoever. Someone comes and says, oh, she beats her children and she's living in this uninhabitable house. And even if they have their family group conference, the point of call after that is for them to file a police complaint, because these are criminal activities. And they file the police complaint, and when they file the police complaint, they then would be able to, through their powers, to uplift the children while they're waiting for the conviction. So when you go to the court,
when agencies working together.
Well, no, because I'm not going to buy into their bullshit. You've got to get your head out of this and just stay focused. What I'm worried with you is that you keep going into their supposed rights and you're diminishing your right. Now, you've only got one right here. They've got hundreds of their made-up rights, thousands of them that they perceive that they have. But you've got one. Your one right says that they can't remove your belongings, which are your children, without a conviction. So it doesn't matter their rights. This is your one right. So they should have made the accusation to the police, uplifted your children, and then this is where your right, now they've got all their hundreds of rights, this is where your right comes into play, because you then had the right to go to the court and present your case to the court, and then the court would have decided that you were either guilty and you would have been convicted, and they had the right to keep their grant of forfeiture, or the court would have decided that these accusations were groundless. It was not up to them to decide whether the accusations were groundless or not. So they have overstepped their power. So this is what we're going to say. So what we're just going to say is we're just only going to say to the judge, could you grant us a declaration that the forfeiture of my children is illegal without conviction? That's what we're going to ask. Now the judge, hopefully, He's not really going. You don't need to give him all these details because he is not supposed to be involved with any of the details. This is the High Court
giving the declaration.
He's only going to give a declaration that there was a forfeiture of person without any conviction, and that forfeiture is illegal and void. That's it.
Yeah.
So then you're going to take that to the lower court. Now, you're also going to have, of course, your oath of allegiance to the Majesties, which is presently Queen Elizabeth, but previously it was King William and Queen Mary. So you must do your oath of allegiance. Otherwise, you can't use this document. See, this document here, not every person can use it. If they are a person of a Jewish faith, they can't use it. If they are a person of Catholic faith, they probably won't use it because this is specific to Protestant people. And part of having this is that...
and Maoris actually, because of the treaty, because of everything else, can use it.
Well, the third article of the treaty says that the New Zealand Maori... Let me just bring up the third article so everyone can see. I hope you don't... am I going to be able to... we'll look at it and see if we can put it up for people to see. But we're just letting the people know. So here is the... we're going to type in here the Treaty of Waitangi. I'm going to send this to you, and then if you give me permission, I'm going to post it. But if you don't give me permission, then I'm not going to. But you can still use it. Okay, so this is our little case, New Zealand, that we're going to experiment. We're going to do experiment. Then we're going to go to the original version of the treaty, and we're going to look at... There are no articles because this is a whole document. And so the ones that they use have got articles, but in an actual fact, in a whole document, in a true constitutional document, there are no articles, and there's no articles here. But it says here, where does it say? In consideration thereof, Her Majesty the Queen of England extends to the natives of New Zealand her royal protection and imparts to them all the rights and privileges of British subjects. And the rights and privileges of the British subjects are, in fact, these 1688 rights here. So you come under that, and anybody who... This is a birthright by anyone who is a descendant of the peoples of the Commonwealth. And you also have another little thing here, which I'm going to give it to you. This is the 1865 Native Rights Act, and you'll see it. So let me see if I can get the right one here. The 1865 Native Rights Act. This is here, and it says that what had happened in 1865 is that the New Zealand Maori had to go to the court and fight for their subject status, because there have been times throughout history where people have, or religious organisations have denounced the New Zealand Maori subject status rights, and they actually went to the court in 1865, and they got a declaration from the judge to declare themselves as subjects, and this has never been repealed. And here it says, every person of the Maori race within the colony of New Zealand, whether born before or since New Zealand became a dependency of Great Britain, shall be taken and deemed to be a natural born subject of Her Majesty to all intents and purposes whatsoever.
Oh, yeah.
Do you understand that?
Yeah. Yeah.
So that means that you are entitled to use these rights, and you
Definitely.
should use them. And so that was a clear case of where the people went to the court and got a declaration. And you are
Yeah.
going to be the first person in New Zealand to go to the court and ask for a declaration in regards to your right of, where is it? The grant of forfeiture, which the Oranga Tamariki gave a grant to forfeiture your children before you were convicted of anything. And you're asking the judge to declare that that is illegal and void. Their grant of forfeiture was illegal because they did
Now,
it.
with these declaratory, right, you know, when you go to the High Court and you ask for these declarations, can it be done with respect to, say, setting up your own hapu as well? Is this where you would proclaim your hapu in order to have self autonomy and self determination?
Well, that's another video. So that
Okay.
it's another
Oh,
topic.
you're on video right now.
This is on video, and I'm hoping if it works out well that we can post it for people, because there
Okay, just edit
are
that last part out.
thousands of people in New Zealand that have had grants of forfeiture of their children with no
Oh,
conviction.
yeah, I know heaps.
Thousands.
Or-
And I'm
Or
saying,
if you just edit that last part out, that's fine.
no, it's all right. We'll just leave it there. It's all right. Everybody knows that Kate Floss's videos are pretty bad, but everyone gets the gist. So then we're going to go down to, we're going to ask for the declaration. Now, that I explained to you before, the subject's liberties to be allowed. Now, this is talking about the declaration. The judge will give you the declaration, and then the declaration will say the articles, clauses, matters therein contained by the force of the law made in due form by authority of Parliament. We do pray that it may be declared and enacted that all and singular rights and liberties asserted and claimed in this said declaration are true and ancient and indubitable rights and liberties of the people of this kingdom. So, his declaration that you will then take to the lower court is saying that these are your rights and this is one of your rights. And this declaration is saying to the lower court judge, when you take them to prosecute Airanga Tamariki, that the High Court judge is saying that this right shall be esteemed, this right shall be allowed, this right shall be adjudged, this right shall be deemed, and it shall be taken to be, and that all and every particular aforesaid shall be firmly and strictly held and observed. So the declaration is telling them that you must observe this right. And then he's saying, as expressed in this declaration, and this is to be observed by all officers and all ministers and all judges whatsoever that serve the majesties. Do you understand?
Yeah.
So this is talking about the declaration, and the declaration will be in regards to the grant and forfeiture. The grant, the Oranga Tamariki gave a grant to the forfeiture of your children without any conviction of the accusations that you were accused of. And that made their forfeiture illegal.
Yes.
Didn't it?
Yeah.
So there is really no need to go into the family court, the family meeting, or they said, he said, she said, whoever said. There's no need to even discuss any of that. You just only focus on that they took your children with no conviction.
Yeah.
And let them argue their thousands of rights that they think they have. And you can see this. You can see this clearly going back to the 1865, where the New Zealand Maori went to the court and they asked for a declaration from the judge to be subjects. And it says here, shall be taken and deemed to be. You see,
So this is the 1865 native rights.
Yeah, the 1865 native rights says here, so you can take this with you also to the High Court judge. And it says here, this is where they ask for a declaration. And it says here, shall be taken and deemed to be natural born subjects. Well, this came from the subjects' liberties shall be esteemed and allowed and deemed and taken to be. This is this is him making, this is the judge making the declaration for them. Do you understand?
So, so once we have that declaration, it's pretty much taken away all of the argument and placing it under the grants of forfeitures because I've been one of the subjects.
It does. So I'm just keep telling you, Hine, that you keep going into their arguments because they have brainwashed you for 2 years or how many years they've been in your life annoying you. They have brainwashed you that they have all these rights. And what I'm saying to you is that every time that you go into their rubbish, you are diminishing your one right. And your one right says that they have to have a conviction before they can give the grant to their officers to forfeit your children, the forfeiture of your children, do you understand? And because they did not do that, everything else is void.
Yeah.
So
everything.
So let them argue that in court. Don't you argue for them. Why are you arguing for them? Because
I'm so used to.
And yeah, well, they
understand what you're saying.
Yeah, so you, and so now let's see what it says in the 1865. Then after that, it says the Supreme Court, and it says the Supreme Court and all other courts of law within the colony ought to have and have the same jurisdiction in all cases touching the persons and the property, whether real or personal, of the Maori people. In this case it says, in touching the titles of land held under Maori custom and its usage as they have or may have under any law for the time being in all force. It's kind of a long thing. In all cases touching the persons and property of natural born subjects of Her Majesty. In this case, the forfeiture was land, but in your case, your forfeiture of persons is the forfeiture of your children. It doesn't have to be about land. Now yours,
and I understand that.
And see, listen to me, Hine. Your declaration is a landmark declaration because this is going to be an order for all courts to have the same jurisdiction in all cases in regards to removal of children. I don't know I don't know how New Zealand has allowed this right of yours to be ignored for so many years.
Because of the fact it has been going on for so many generations.
Generation after generation after generation, the Maori courts of justice and the Maori, whatever they're doing, have told you that your rights come under some kind of a Maori rights, and that this is flexible. It comes under tikanga law.
They don't even tell you your rights.
You have no rights. And listen to me, under tikanga law, you have no rights. But let me tell you, all the tikanga law, all New Zealand Maori councils or whatever it is that they want to set up, they are all actually bound to this 1688 Bill of Rights. They may not be bound to any of the New Zealand government laws. They may not be bound to any ministry laws, but they are all...
No, but they are still bound to the agreements that they made with the British subjects and the Crown.
Well, you were born with this right. And so
I understand.
And so they have been telling you, that you come under a different law and all of this. And then what have they been doing? They've been trampling all over you. They've been using it as a tool to take away your God-given rights. This is terrible. Yeah. And so you are going to be the pioneer to re-establish all of the rights, and the Orangi Tamariki and I don't know what the heck they're doing. What
they want.
They are doing whatever they want, and
they're using every single other agency available to go with them on whatever they want, because it's all about money.
Well, they're using all the Maori agencies, though, that have been having billions of dollars pumped into them.
Yeah, and the police. They're using the police as well.
Well, no. They're using them in an illegal way.
Yes.
Because no convictions. I mean, to be honest, if you have... now, I just want to let everybody know that Hine she's a lovely, lovely, lovely lady, and these accusations have never even seen the light of a court, but they said there was an accusation that she may have, we haven't got exactly the accusation, but something to do with hurting her children. And so...
Now, just to correct that, it was taken to court. However, the lawyer that was appointed for me did not give any of my evidence to the court. And when I tried to fight, with what little knowledge I did have back then, when I tried to fight, and I did this through family group conference, through meetings, anything that I could, I was pretty much blocked at every avenue, and they tried...
Right, stop. I just need you to stop. Were you convicted?
No.
Right, so why are you bringing that up?
Because you said it never went to court.
Oh.
They have to take it to court. I'm just...
Yes, but there was no conviction, though. Was there a conviction?
No. There's no conviction.
Right,
but the court process was to uplift the children, so I'm just trying to...
The courts, but the court also did not convict you, but uplifted your children. Is that right?
Yes.
All right, so listen to me. So you have to be so careful here. How you went into, no, this is what we should be saying, is that they sent it to court and the judge did not convict you, but the judge gave a grant to remove your children.
Yes. What I was doing was correcting you, because you said it didn't go to court. It did go to court.
All right, okay, so I will correct myself. Yeah. All right, yeah, okay, correct myself.
That's all I was saying.
So, okay, yeah, so, okay, let's go back to there again. Okay, so Orangi went to the court, and the court did not convict you. The Orangi went to the court with an accusation of violence, is that one? An accusation of an uninhabitable home is two. Yes. An accusation of addiction, is that right?
Yes.
And the judge allegedly, okay, so I'm just saying allegedly because I don't want to get caught for anything illegal, but we're not mentioning names. But the judge, to my understanding, he granted a forfeiture of your children, but the judge did not convict you of any of those charges. Is that correct?
No, that's correct.
So that is where the grant of yes. So that, but this is where the grant of forfeiture was happened. It did actually not come from the Rangatamariki. The grant of forfeiture came from the judge. And he did not convict you before he gave the grant.
Exactly.
And there has never been any conviction. So that comes under also the excessive bail. Because there was an excessive bail here, because the bail has no time limit. That is the excessive bail, because there was no, so probably what under my understanding of your rights would be that he would grant a forfeiture. I suppose that there should have been a forfeiture, and then there should have been a time of bail, which should have been an amount of time where you should have gone to the court and been convicted of those charges. And then if you were found guilty, the grant of forfeiture could have been made permanent. But if you were not found guilty, so this was, this is, quite an abuse of power here. So
definitely.
What they're doing is mixing up all of the procedures so that you are left powerless.
Yes.
Aren't they?
Yes.
So
that's true.
They do have certain rights to a grant of forfeiture if there is a danger. But following on to that, there should be a bail. A bail of a certain amount of time. What they have done is they have forced you to fight your case at the same time as they were doing the forfeiture of person.
Yeah.
But what they were supposed to do, in my opinion, is to go to the court and ask for the forfeiture of person, and then the judge should have, because there was no conviction, they've just left you in a legal limbo here.
Yeah.
Because they have kind of left you with no conviction, but given the grant of forfeiture, but at the same time never prosecuted you specifically for those charges, and you got no conviction. And since they have not prosecuted you and you have got no conviction, the forfeiture just kind of carries on in this legal limbo. It's kind of hard for me to explain, but I see what they've done.
Yeah.
So what we're going to do is just simplify it and say that there was the High Court judge doesn't decide on any of these. All he's going to say is that there was a forfeiture of person and there was no conviction. That's it.
Yeah, that's it.
Is that right?
Yeah, I mean, I would use the excessive bail if needed. But I think we can pretty much cover it in grants of forfeiture.
Yeah, because I'm wondering if we need to use that excessive bail and we just only can focus on the grant of forfeiture without any conviction.
Yeah, well, that pretty much sums it up. To go into excessive bail, that would be, if we were wanting to do a claim after with regards to prosecuting Wananga Tamariki, then I would use excessive bail just to explain that it was cruel and unusual punishment for something that was illegal and void.
Because there was no bail given.
No.
Because what I assume should have happened is that they go to the court and they would say these are the accusations, and then the court would grant a short forfeiture with a bail condition that it would be for the amount of time while they took these accusations through to get the conviction.
Yeah.
And then when the conviction was made, then the forfeiture would become more permanent, or if the conviction was not made, then you would have to get your children back. Is that right?
Yeah.
But what they did was they never completed this case.
They didn't let done it behind the scenes without me.
Yeah, they've left the case uncompleted for you so that you have nothing to fight with. So I'm not sure that I would use that excessive bail. I think I would just go with the grant of forfeiture.
Yeah, well, that's all that's needed is the grant of forfeiture.
Yeah, and nothing else.
Yeah, just leave it simple.
And I wouldn't even bother talking about the case. I would just say that your children were taken and there was no conviction. That's it.
Yeah, well, probably don't really need to go into the case.
I don't think that you need to, Hine.
Yeah. No, I don't think so either.
You really don't need to even talk about what any of it. There was an accusation.
Well, no, that's done enough talking.
Yeah, I think you've been talking for years and getting nowhere. Just say this was the accusation, and the judge granted a forfeiture of my children with no conviction. You're asking for a declaration.
Yeah.
And what they're going to have to do is take you to court and prove their case in a court of law.
And they won't be able to.
Well, who knows? Who cares? This particular grant was illegal.
Yeah.
Wasn't it?
Yeah, it was definitely
illegal. And so this is a landmark case because it's going to stop them doing this to thousands of people. That they make it's very sneaky. They make the accusation. Yes, you can see now, can't you, Hine?
It's extremely deceitful what they've done.
They make the accusation. They take you to the court. The judge grants a forfeiture based on safety grounds, and they never send the accusation to a completion of a conviction or non-conviction. And you are left fighting them for years and years, not realising that you can't fight it until they have until they have finalised the case of conviction or not conviction. You can never fight this case. Never. That is sneaky. Isn't it?
Yeah.
By
placing it in limbo, they can and they have this thing called attachment theory. So if the children get attached to the carers, there's only a 2% chance that any family will get their children home. So that's what they go on. They have that secondary backup. So to leave people in limbo is to actually it's deliberate.
It is. It most certainly is, because no, this cannot go on in any country, or especially in New Zealand, any longer. We are going to nip this in the bud.
Yep.
All right. So, but all we need you to do is to, I'd take out the excessive bail.
Yeah, that's fine.
But what we need you to do is not to go in to any of what they're saying, or we're just going to only say, I was not convicted.
Yeah, well, you're right.
I was not
There's
convicted.
no conviction, therefore it's null and void.
Therefore it's null. It's so clear, it's so simple. There is no conviction, and so it is null and void. Isn't it?
If you're going to uplift children on the prognosis of an issue that is criminal or illegal, then why wouldn't you follow through with prosecuting those people for that crime?
Well,
and if you're not doing that, then you're actually not upholding the Care and Protection Act.
Well, that's illegal for a start, because if they have knowledge
Exactly.
that someone has committed a crime against a child, and then they're not doing anything about it, that's illegal in itself. Because their laws do say that if they know that somebody has abused a child, they must report it to the police, and the police must prosecute it.
Yeah.
They must, by the law. So they're all breaking laws here. They're all breaking their own laws here.
Yeah.
The only one that didn't break any laws here was you.
I know.
Isn't it? Don't you feel fresh and empowered by that?
Yeah, I do.
And so
it's
then
so simple.
It is that simple. And it's just because you have the right to go to the court and present your case to the court, and they must give you a conviction or a not conviction. They must.
Yeah.
And so any grant of forfeiture without doing that is illegal and void. And so this is a landmark case. Now the judge, so that will go down to the subjects, we're going to round it up, the subjects' liberties to be allowed. And if the judge makes the declaration for you, it shall be allowed, adjudged, deemed, and taken to be. And it must be firmly and strictly held and observed by all, in this declaration, by all officers, ministers, judges, and you can see it by the declaration that was made in 1865, that, what does it say? It shall be taken and deemed to be. And so that is the declaration there again.
Yeah.
So yours is a lamp. We're going to finish it. I'm going to stop my video. Is there anything more that you want to say?
No, that's all.
So I'm going to still be here talking, but I'm going to stop it for the people. All right.
I need to edit out that hapu bit.